Come on. Come on.
Put your emojis together for Auntie Miracle B.
I'm swole in this shit, look at my Pico. Hey, drugs, guns, murder, that's all we know. Hey, I jumped off the porch, I was a preteen. Yeah, running through my city like a track meet. I'm the kids in this shit, I gotta run it up. I'm turning down to a brick, I'm trying to run it up. Mama gotta pay the rent, I gotta run it up. Nobody never gave me shit, I gotta run it up. I was born in this shit, I had it hard. Mama bust her ass working like 3 jobs. Teachers told me I was one to beat the odds. But I was learning math and learning how to ride. For my first time, decided I was 9. For my first bag, ran into a 9. From school, I'm a tracker full of time. I try to stick up on my life and bitch around. Jumping through the city, I can count me up. Yeah, I'm bullying with the brother. I was small in this shit, look at my Pico. Hey, drugs, guns, murder, that's all we know. Hey, I jumped off the porch, I was a preteen. Yeah, running through my city like a track meet. I'm the kids in this shit, I gotta run it up. I'm turning down to a brick, I'm trying to run it up. Mama gotta pay the rent, I gotta run it up. Nobody never gave me shit, I gotta run it up. I was born in this shit, I had it hard. Mama bust her ass working like 3 jobs. Teachers told me I was one to beat the odds. But I was learning math and learning how to ride. For my first time, decided I was 9. For my first bag, ran into a 9. From school, I'm a tracker full of time. I try to stick up on my life and bitch around. Jumping through the city, I can count me up. Yeah, I'm bullying with the brother.
Can y'all, am I on? Okay, yeah, I am. Hey, everybody. Welcome, everyone. Here, let me stop the screen here. Welcome, everyone. How's everybody doing today? How's everybody doing today? Huh? How's everybody doing? Huh? I've been a good boy, and I've been a little sock gremlin. I done stole mommy's socks. I stole a dryer ball. And I got all of my toys. It's miraculously appeared everywhere. And even got toys in the bed. All in the bed. I like 5 toys in the bed. And then 5 on the sofa. And then I keep trying to break into my toy chest. How y'all doing? Woo! Okay. All right, Munchkin. Hold on. How's everybody doing today? I missed everybody. Welcome to everyone who is here. Oh, I can't see. Hey, Steve, Miss Tanya, Chantal, Sean, Vizini, Stellar, Katie, B. Blanco, Charlene, Amanda, Kathy, I may have said something. Daniel Berry, Sports Highlights. Welcome, Trina. Welcome. I'm blind, y'all. Forgive me. Okay, I think that's everybody. And Kayla, welcome. It's so good to see y'all today. I have been busy. What have I been doing? None of my business. Oh, and I don't know what my anniversary, my 29th birthday. But my mom baked me some cookies for my birthday. Yes. I'm not gonna be up here for too long. I've been watching the freaking YSL and that's been very entertaining. 8 hours of time wasted. I don't know what in the world that they doing, but hey, I'm here for it. I'm also here for. Oh, you want to see Paisley? Come here, Munchkin. I'm gonna be. Come here, Sarah Boone. Come here. Don't just sit there and look at me. Come here. Quit wagging your tail and come here. Come here. Lord, you know my back is bad. Fooling with you. Here you go, Robin. Here's Paisley. Oh, thank you, Kathy. I appreciate it. Yeah, that's the business. Hey, Super Kelly G. Hi, everybody. Oh, hey, Gina. Like I was saying, I've been enjoying watching the YSL, and then I did watch the Sarah Boone hearing today, and that's going to be an entertaining case, her representing herself, and I will definitely be there. I will definitely be there. Paisley. See, but I had a Shih Tzu before. He used to be able to just sit up on his hind legs, but Paisley doesn't do that. Not unless he wants food or something. Oh, thank you, Angel. And hey, Marianne and Robin. Okay, here you go. All right, so y'all done seen Munchkin. But anyway, I finally found the rest of the COVID thing. And I said I was going to come back with that. And that was on day 2. That's why I couldn't find it. So I had to find it. And then we're going to do that part. And then we'll go back to the rest of day 1 or part of day 1. Hey, Deb. Oh, hey, Ruthie. Hey, Munchkin. Ruthie told me to tell you, hey. You go to school tomorrow, Munchkin. Anyway, we'll go ahead and get this party started, y'all, because we're not trying to be up here all night. Oh, I was in a chat with Tiffany Henyard. Their meeting is now, and it's some hood booger ghetto bat mess. She need to go to jail. And somebody said that she going to jail and they're going to have a special cell just for her wigs. I was like, I'm through. I am through. Anyway. Oh, well, thank you, Marianne. Y'all make sure that y'all smashing that like button on your way in or out. And please share the stream. It would be greatly appreciated. It really helps out my placement in the algorithms. Okay, here we go with this doofus. Hey, this little bitch. Crying.
Provided with information that your test result was hand delivered to you, folded. Did you receive that?
I was made aware of my test. I didn't look at it yet. So
Do you have it with you?
it is. It's in my paperwork somewhere.
Somewhere.
All right, I need you to locate it and open it up, please.
May I ask the reason why that would be?
Mr. Brooks, you raised this issue yourself, and I'd like to know the result.
I would too, but I was kind of in the middle of preparing for my defense. So
Mr. Brooks, find the piece of paper and open it up and read it, please.
Your Honor, I don't consent to being talked to in that fashion.
He looking like, bitch, I know that your motherfucking ass ain't saying nothing to me. I know that your snowflake ass ain't saying nothing to me.
Lack of consent is noted for the record.
I'll punch you upside the face.
Please find the piece of paper, open it up, and please read it.
I will not consent to that, Your Honor. Or do I agree to that, Your Honor? I do not.
Because ain't no white bitch gonna tell me what to do.
Mr. Brooks, then I'm going to advise the Sheriff's Department to find the piece of paper and hand it to me so that I can read it.
And
So that those are your two options.
what would be the basis for that, Your Honor?
Mr. Brooks, this is an issue that you raised, and I need to bring it to finality and know what the test result is.
Hey, Mandy.
Okay, with all due
Hey,
respect,
Tammy Lynn.
it was a motion that I raised.
All right,
or-
I'm going to clear the courtroom. We're going to go off the record, and we're going to find that piece of paper, and I'm going to address it when that's done.
All right, let me fast forward on to the place. Because I see some ladies tonight that she be having my baby. I'll tell you another case I'm looking forward to whenever they get its ass is Puffy. I'm ready to see all the people he didn't had knocked off. Because, you know, he responsible for Tupac and Biggie. But, you know, I've been saying Tupac been alive. You know, he on an island somewhere because he didn't have too many albums, you know, released after his death. What, Munchkin? Quit! Don't even start. Don't start fussing. Lord, that's when this hoe was gone for a long period of time.
And
Here we
it was
go.
brought between Mr. Brooks
Oh,
and the deputies. Ultimately, though, I think he was taken into the bullpen. He was brought back out, but it was very clear to me that he was upset. I think understandably so, but I needed to make a record of what was being done.
Y'all let me know if I am too loud or you can't hear anything. Just let me know. Because, you know, sometimes my older videos, you know, I was really, really super loud in the mic. My mic was turned up and I turned it down. So I just want to make sure that, okay, good. I just want to make sure I'm not blowing out your ears and your headphones or in your speakers. So, okay, I'm be quiet.
Including that I have obtained the test result. So there's an accurate record in this case related to the motion that was raised previously by Mr. Brooks. I want Mr. Brooks to know that I am not removing him from when the jurors are brought back in. It was just simply because he was upset. He was very loud when I walked into the courtroom before going on back on the record.
Hey, Carrie.
He was yelling about his constitutional rights being violated. I advised him that if there was any type of use of force.
Ain't that true, Deb? Isn't that true? 2 years later, it's going to be 2 years in October, the most wonderful time of the year. And we're still watching this foolishness.
With additional testimony, ultimately, I'm going to take an early lunch break because
I know you
of
are.
this. But I will make a record of the following. I have the result. I am going to scan it.
J9 Eve, she might not want to be doing Darrell anymore because, I mean, it's tiresome at times listening to this idiot over and over and over. And so you have to have like a palate cleanser. So, you know, maybe she'll get back to it. I don't know.
Department to provide that result to me. And it will remain under seal. I realize I'm disclosing that result, but I feel obligated to do that given the motion that was raised 2 days ago by Mr. Brooks.
Oh,
again, I intend to take an early lunch.
Poor baby.
So that will hopefully give Mr. Brooks an opportunity, if he so chooses, to review the result himself. It was put in front of him.
She's so ready to go. She is ready to go. She got her side salad waiting on her. She has her chicken and kale Caesar wrap waiting on her.
During the recess,
it's time for lunch.
Mr. Brooks will also be given the opportunity to change into street clothes if he so chooses.
But when
we come back, he will be in this courtroom. I agree. Mr. Brooks was making a couple of statements about how he was abiding by the rules and being respectful.
Yes, Sarah Boone's farm. I love that. That's gonna be hilarious. Oh, now that you mentioned Sarah Boone's farm, if y'all watched the YSL today, I don't even know what the hell they were talking. They keep talking about this ex parte meeting that they shouldn't have had. And so Love, who I called Juana Man, she was cross-examining, or maybe she was doing a direct examination of one of these peoples.
And articulate.
Okay, he's not talking. One of those peoples, and from a distance, it looks like Drake. And so, I said in the chat that was a Temu version of Drake. People were saying that was an AI version of Drake in the courtroom. And somebody called him Boone's Farm Poppy. Oh no. Oh God. Oh God. These white motherfuckers in here. And they got me in here. It's cold in here too. Why they doing this shit to me, man? Why they doing this to me, man? I ain't do nothing wrong.
They're in recess. Probably come back at.
Oh, I'm so drained. I'm so tired. It's like I'm Kunta Kinte on the plantation and it cut off my foot. All right, anyway, back to day. What is this? Back to day 1. We going. YSL it's embarrassing. I have second and third hand embarrassment on YSL. Okay. Day 1. Where we at? That's pretrial hearing. Oh, I look at Mushmouth Joe's since his is significantly shorter and a lot less annoying. All right. But yeah, YSL is embarrassing. It is. Girl, Super Kelly G. And you know what else? I'm so glad you mentioned that. Yes, it does make all of us melanin kings and queens look very bad. And just so some of y'all know, hey Gunner, just so some of you know, if you come in my chat and I don't acknowledge you, you've probably been blocked because I may have seen you in a chat room somewhere and you have said some things that I found personally offensive. Like, for instance, whenever I see DEI hire, I get immediately annoyed and I immediately block you because what you're telling me is unless the person is a white male, then they're not qualified. That's what DEI hire means to me. And these are people who are duly elected officials. So if you want to critique them for being stupid and incompetent, I'm with you on that.
Darrell Brooks case.
But if we're making this a racial, ethnic thing, I got a problem with that. So all of my friends, my light skin, and what I mean by light skin, I mean light skin friends. When you say that phrase, DEI hire, you're basically, and if you're talking about a black person, you're basically calling them the N-word. So I would suggest you not do it before someone gets a white folding chair to your face. Don't say that anymore. I'm trying to help you. Don't say that shit no more. Okay? All right, let's continue. Now, talk about them being incompetent. I agree with you, and I'm with you. But not because of their gender or their ethnic background. I don't think so. We're not going to do that. Yeah, we're going to go to accept for value, return for value, blah, blah.
It's number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Upper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
Oh, yeah, I can't. I forgot he does this every time. Hold on, let me get to the real. Look at this ugly bitch. Okay, let me get to the real one. I forgot Mushmouth does this. That's annoying. Okay, hold on one second, y'all. I'm sorry. Let me get this. That is annoying. What am I trying to type at? I'm crazy. Okay. Darrell Brooks, day one. All right. Look at this 10 hours long stream. Ridiculous. And you know, we're going to skip over a lot of it because they're reading. Okay, here we go, y'all. I'm sorry. Here we go. Share. Sarah Boone's going to be so fun. And that hearing that she did today, oh, she was so annoying. She is definitely America's Karen. Definitely. Okay. Well, look, we all get along, and some people don't understand when they make certain statements how that is interpreted by people outside of their immediate, as Darrell would say, vicinity. So I'm just doing my American tax-paying duty and just letting you know, don't do it. We all friends here. Don't do it, period. Please. Oh, there we go. I love my trolls. I love it. I love it. I love it. Okay, let's go. What's up, Block Party? Hey, wish you Karen Wood. You know what? I haven't checked Charlene. I don't know where this idiot is. And I'm sure he's still in PC.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning.
He is such a freaking child.
By District Attorney Sue Opper,
See, all this twitching and switching he doing.
District Attorney.
All this twitching he doing. This is what children do. This is what kids do. Bored kids at school or at in church.
So like the record to reflect that he
look at him. He can't wait.
In jail attire today.
Come on.
He's also wearing a mask.
I do not identify by that name and would like the opportunity to state that I'm here concerning this matter.
Bitch, why don't your dusty ass just sit down instead of bending? Are you trying to air out your booty hole because it got blown out the night before? Is that what this is? You can't sit down. That's why. Is this why?
As third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. Woo! I'm asking you to respectfully not interrupt me. That's the second time.
Candace Owens. What? Candace Owens. Let me go.
And so I can go through the list of things that I need to get through this morning.
I just wanted to state it for the record.
Mr. Brooks, it wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor,
saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted. All right, but you need to stop interrupting me so I can get through what needs to be done.
But it is
I have a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. I will remind you once again of the.
Don't Darrell look like Michael Jackson around the what time period would this be? She looked like Michael during the black or white phase. Can you just imagine like the little hat and no glasses? And they sort of look alike. Michael and I know you're not that Candace Owens, Candace. I was just messing with you.
Supreme Court rule. It's on a yellow laminated, double-sided
awesome
piece of paper that is before you. I checked, I verified, it
I
is
accepted and returned it to
Mr. Brooks.
value,
That's
Your
yet another interruption.
That looks like this is Michael. Michael is Jennifer Darrell. I have cracked the code.
Let me get through this, please.
I just want for the
You will
record,
have an opportunity when I
I'll-
give you an
I want
opportunity. No
to
one
state
else
it.
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Sit
Mr.
your
Brooks,
ass
I am going
down.
to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another
I
interruption.
intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now.
I intend to follow decorum, even though I'm not following decorum. I don't even know what that shit means.
Now, this is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another interruption. I'm well aware. Stop
respectfully, which I
talking.
have the right to do.
I'm well aware, Mr. Brooks,
I
that you
have not
object to the
intended
name that
cause any,
has
disruption.
identified on the information and all documents in
wanted
this
noted
case.
for the record
Your
that I do
objection is
not
noted. It
identify
does
by
not
that
need to be
name.
repeated. I will
Lord bless this woman. Bless her heart. Bless her heart. Bless her heart.
make a record right now. The
May I
court
have the
notes a
opportunity to preserve
continuing
my right, Your
objection by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously
you go.
Never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I tried
of
to
record.
state
There's
that
another
for the record,
document that's
Your
filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom.
Y'all make sure y'all smashing that like button. I got 81 viewing and 48 likes. Can I please get my likes up? Thank you.
Where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And you
interruption.
haven't shown me any lawful case law that I can be removed from the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and
Coercion, not coercion. 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 Like a coercion. Hey! The dusty Darrellisms.
case law that I can be removed from the court
Mr. Brooks?
proceedings.
Even if she got you some case law, you wouldn't read the shit. No, look at him. He look high. You wouldn't read the shit. No way. You got all this stuff. Remember all these boxes. You got so much stuff in all these boxes that you got to go through. You don't have time. So you're not gonna read the case law.
In a trial and forced under coercion and duress
Duress.
to appear in the trial.
Duress. Either D-U-R-E-S-T or D-A-R-E-S-T. Duress. One of the two. I'll take either one.
That I am needed, that I'm trying to express that I have the right to
Mr.
be
Brooks, there's a
present for.
proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom. So
respectfully
you are
object to that,
once
Your
again reminded of that. I'm going to give a little slack at the moment, only.
Oh, she writing down the number of interruptions. I tell you, this whole is thorough. Darrell is thorough.
Because we are not in the presence of the jury, I'd like to go through a couple of things. The first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements
That'll
by
work too.
allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around each one of the tables. I'm aware of the feet shackles. That's yet.
Thank you, C. and Nikin. Thank you. I appreciate that so much.
Another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly, all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, their arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes. And the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who are in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings.
I mean, Miss Tanya, I mean, he technically is sort of dead because, I mean, you got like 1,000 years. So, yeah, he's technically kind of dead. So, I mean, you're right. He is sort of dead.
This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect,
I'm a bitch.
I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street clothes?
I do not consent or agree to anything that you just stated, Your Honor.
Bubba right here is like, this dumbass. Like, why you wanna be looking like an inmate in front of the jury? Or all these ugly, cheap ass tattoos showing.
All right, he did not provide an answer to a very direct question.
You.
Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption.
She writing them down?
I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about whether you would go back to the jail. That's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily and intelligently. No one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie. but it is his choice to not do that, and we will proceed accordingly.
So
Very
while
nice
we're on the
suit
record,
tie.
now challenge the subject matter jurisdiction.
No, you may not, sir. You need to file a motion in order to do that.
So
Mr. Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
You just weren't speaking.
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I'm
had
under
a
duress
dozen or
by having
more interruptions.
I
We'll
have
be
shock-
off the record while we
Shocks
do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. Well, I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not.
Oh, help him, God. Help his dumb ass, Jesus. Give him strength. His dumb ass. I bet they all in there like, thank God this fool is out of here. I know what is this detective whatever his name is right here. I know he can smell Darrell because he's real close. I know he's just like, thank God. That's the reason why he retired. He's like, I can't do this. Hey, Sadie, and the best mama bear, Raven or Ravion, whichever one. Detective Casey, thank you. I know all these people that it just loses my, let's go. Look at all these papers. And they prepared. Look at this fool. I bet that table glad and that chair glad that he gone. Everybody glad. Okay, what are we waiting on?
All right, we are back on the record. The case is ours. They were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. Every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record that at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back.
Is there heaven for a gangster?
To give him headphones, since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things unless he can play.
But Zenny, I don't know how anybody could resist all of that man. I mean, it's just so much man that I don't even know what to say or do. I'm I just don't know how anyone could resist all of this. I mean, it's just
system to the other. That is why we're
who can resist all of this? Look, who can resist this? He is sexy. He is sexy. SEKSI. Sexy. Yeah, he's sexy. Right?
And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that
the best mama bear, you lying. You can't. Oh, hold on. You can't resist all of this. You can't. No woman can resist Darrell.
to indicate that trial judges that are confronted with disruptive, contemptuous stuff.
Blah, 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 blah. Yep, yeah. She over here, she talking all that shit. And, and she think I'm stupid. She think I'm stupid because I'm black. That's why she said, I'm sitting here and I'm standing on business. I'm going to stand on business. But see, y'all ain't doing nothing to help me. Y'all ain't doing shit to help me. Y'all is in here just laughing, kiki, and he, and I'm in here. I got to suffer. I'm sitting on business on this table. And I'm going to let y'all know. First, it was Malcolm, and it was Martin, and now it's Darrell.
I gave him the opportunity to go back
political
to the jail to
prisoner.
put on his suit and tie or other street clothes. He refused to answer that question.
Political prisoner.
This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that.
And y'all, my co-host left me. Anytime I do Darrell, he leaves. Munchkin left.
The courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back, and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself.
See, you white motherfuckers, y'all racist bitches, y'all done grab me. And you see, I got this on my hand. I got all this on my hand. Y'all did all this shit to me. Y'all some racist pieces of shit in here. Y'all just racist. I didn't do nothing to deserve this type of treatment. Nothing.
On the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving.
I need somebody. I need a nurse or somebody to come check out my hand. Y'all bruised me. Y'all hurt my skin. It's so soft and supple. Oh, what's it do? Oh, what we doing?
Behavior, whether it be appearing in another tactic of his to disrupt.
What is this? He over here shaking and gyrating and
to delay, to
why he oh yeah, for my light-skinned friends, right? Because I know y'all don't really have ash like that. This little, you can barely see the little white speck right here. That means he need to lotion up, or he need to do that real quick. Because he ashy, he dry. Just like his personality and his soul, he's dry. He's dry.
To create.
What is that though, y'all? He's wagging his tail like a dog.
Something that I've said, I believe he can adequately hear, and that his statement earlier.
Let me slow that down. Oh, child. That is hilarical. And I'm going to keep you mute. I want to hear your mouth. Yes. Oh, y'all get ashy? I didn't know. Okay, so y'all get ashy too. Okay. What's he doing? Why is he gyrating and jiggling and wiggling? Why he doing that? Okay.
Behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear if appropriate.
Look, when you looking at a watch, you don't have no watch. I doubt you can tell time.
I've received a note. We need to reset the Polycom system.
Hey,
so I'm not sure what that means. I'll find out.
I think you better call Tyrone. Call him.
Out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room.
Yeah.
At this point, we're going to take a short recess for that resetting to take place.
Hey, Mike.
Then I want to go back on the record. Absolutely.
All righty. One of the many. I'm trying to see. I don't want to hear a bunch of talking.
The information I received was that all of a sudden the audio was only going through 2 speakers and not all of that would be my position. It's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case. And you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense.
Somebody, man.
Waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to
what happened?
He is coherent. He is intelligent. He knows the issues in the courtroom. He discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion.
She's right. He is competent to stand trial, and he does understand. He's just stupid as hell. As hell.
The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this.
Like, I ain't even got the right shoes. Yeah, you need to wipe me down. Wipe me down. He's like, okay then, buddy. If you're not going to take it, then fuck you. I'm going back over here to my chair.
Mr. Brooks are deliberate and intentional, and they have escalated. And the court has seen this since August 25th or so. As the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time.
Hey, Kathy. Oh, I'm sorry. Rivka. I don't know. Rivka. I'll just do this. She can always go to the spa that Carly Russell used to work at, the whatever the spa name is, with the great robes that she stole. I'll remember it in a minute.
Of Darrell Brooks to proceed, and we have had many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need.
So you motherfuckers, y'all over there, y'all ain't doing shit. Y'all not doing anything that I need y'all to do. Y'all ain't helping me.
Speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opera, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. That this behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has a right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks.
And it's important for my upcoming election, because I need this for commercials and ads.
The court goes through these things, frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it with to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday.
Hold on, let me slow it down. Okay.
Specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted.
Am I muted? Am I muted? Oh, it's time. Showtime. Showtime.
Turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in
All
here.
right,
So
thank you
give us
for
a
coming,
second.
Bob Kitten. Bye, Bob Kitten.
Where is the microphone?
Until next
It looks like it's in front of the
time.
monitor. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday?
God blocking it.
Go ahead.
Keep blocking
answer,
the
please.
lies.
All right, your objection is noted for the record, and I'm just putting the mute back on.
Here they are.
He provided that objection without any
Mute me.
legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. There it is.
You know who could play Darrell Brooks? Simone Biles. You know, she's like 4'8", 4'9", and she would fit right in and play Darrell Brooks. You know, we don't have to worry about complexion, you know, well, that's irrelevant. But yeah, she could play Darrell Brooks because of her height.
Try it again, sir. I apologize for the technical issue. All right, the technical, we're going to have to figure that out. It's not appropriately working.
This shit ain't working.
I do appreciate that he was able to hear me because he leaned in to answer. So I just want to make that record. I'll take.
They doing this on
I'm
purpose.
gonna go take a recess. I'll just mute while we're doing that.
Is he wearing a diaper?
Just so I can figure out what the audio issue is, and then we'll go from there.
All right. Oh, Paisley. I'm sorry, y'all. Somebody must have walked down the street.
Has now been.
Paisley. I'm sorry, y'all.
Solely concerned the audio from the microphones in front of Mr. Brooks and the two room systems cooperating, and we were having difficulty in this courtroom hearing Mr. Brooks. I believe that issue has now been resolved. When I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom. I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time,
Oh my God,
I'm
I
not
can't
going to
believe
pause the
they saying
proceedings
this
further
shit.
for him to be seen by jail.
That's some bullshit. I can't believe. Oh my God, I can't believe they saying this, and they won't let me say nothing. I got more than just a cut. I am battered and bruised, bitch. That's right, Paisley. Battered and bruised.
The camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point,
Yes, Katie, I did, and I've still been trying to figure out what a black job is. I've been confused for like a month. Like, what the hell is that? Can someone please explain what a black job is versus a brown job versus a white job? What are these things, sir, ma'am?
given your conduct from before,
Oh,
I'm going to
Lord.
require, after we take the next break, that the sheriff's department
This how he sit when he pop a squat in his cell. He just like that.
and with shackles on your
Hey,
ankle,
Glenn, you're
as
not late at
you
all.
are in custody, and that is appropriate. Now, I want to turn back to the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My
Wow.
next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around.
Like, fuck this white hoe. I ain't finna do shit.
Mr. Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instructions?
Oh, there we go.
I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't allowed to make case. I can't even hear what she's saying all the way, man.
You dumb ass. I can't hear what she's saying all the way, but you're.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's
Hey,
been
Lori.
confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on.
When did he say that?
I'm able to hear, he said to the
Now, Biden said that he wanted a woman. He didn't say a black woman. Now, he said that about the Supreme Court chick, Ketanji Jackson Seriously. But anyway, let's continue.
The deputy put them down. I don't want them. All right, I'm going to mute once again so I continue with my record.
Come
he
on.
did not answer the question, what is the legal basis?
So you won't put on the headset, and then you won't turn around and look at the actual computer to see what she's saying to you. Like, I don't get it. This is the dumbest shit on earth.
For the objection, I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions.
Because I'm the victim. I can't hear, and she's not gonna repeat what she said because I'm the victim. I'm over here. I'm the victim. Everybody failed me. I need somebody to get this shit fixed so I can hear, so I can not pay attention and pretend that I'm listening when I'm not listening. I need y'all to get this shit straight.
The topic of it, Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity.
His mom really failed him. Dawn Woods, she really failed this piece of excrement. She really failed him.
It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed.
What you looking for? You got some shit on your shoes? Is that what you keep moving your feet for? Look at my baby. Look at my baby. Hey, Jason. I want to see you do some tricks. Jason Statham.
All right, thank you. Then we'll move on to the motion.
Thank you, China.
Reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When
you think the mom was having him, told him to act like this, Glenn? Or the Reddit, the Hail Mary, huh?
Only one other observation, Your Honor, that since I filed that, the events of the last couple of days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify. And
I get it. You know what, Jeff? I thought you were talking about the song Hail Mary by Tupac. My bad. You're talking about, the best Hail Mary. I don't know. I'll let y'all decide in the chat. Hold on, let me get to the thinking. Y'all let me know. Jeff want to know which Hail Mary was better, the recall or the Reddit? Which one do y'all think was the best? I think that I think maybe the Reddit may have been the my favorite Hail Mary, but I mean they were both equally stupid. So, hey Vicky.
So not having their faces displayed, I think would help ease some of that tension for those individuals.
Okay, that makes sense, Glenn.
Mr. Brooks, my first question to you is,
the Reddit.
Do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. I'll unmute and provide that to me.
Go ahead. I didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the court's?
He didn't remember. Huh? He didn't remember, but his interrogation, he remembered. That's interesting, but okay.
Sorry, the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify.
A ruling was already, we already talked about that. You already ruled that
Okay.
and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday.
It was
I'm
very,
asking if you have
very
any
concerning.
Position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
What the hell are you talking
It's
about?
a public trial. It's a public trial. Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name.
Wait a minute. So you mean to tell me Darrell was aware on day one that there is technology and that it's a public trial? So then how was he confused on day 15 saying, this is very concerning with the Reddit post? It clearly had to be somebody who is on the jury. It clearly had to be somebody who's in the courtroom. Interesting. Ha!
That in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen. So
I'm gonna stop interrupting, I promise. I was in the YSL chat today, right? And someone said that Darrell Brooks is a better attorney than the DA Love, or AKA Juana Man.
So I mean, that's just the age we're in anyway, as far as with social media and Google and all these different things. We got all this technology basically at our fingertips.
Well, she's both, Tyrone. She's both.
I don't understand
Paisley
how it needs to be changed at this point when it was already ruled that this is a public trial.
I'll be right back.
There's going to be a lot of things that are going to be shown.
Paisley.
Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on the record. Let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion for reconsideration. Essentially, it requires that
I have never seen that before.
Party bringing the motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 US 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I'm trying to do that. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done, up to this point, everything that I could to preserve their privacy. I don't frankly want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I'm aware of Marcy's law, certainly aware of the provisions that the state cites, but the fact remains the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process.
Look at me, we're trying to get them secret documents together.
The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk into this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today. There is no doubt that this case has received great public interest, but this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile witness testifies, may only be captured from the shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media, it's very easily to identify these individuals and search for them in other ways. I also add that there have been a number of news reports, media accounts, newspaper articles about victims naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And
for the love
I want
of
to keep this trial
God,
going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered all of the outstanding issues.
But I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure.
how the hell you didn't hear what she said and she did all that talking? She did all that talking, you didn't hear nothing.
Sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
Oh, you missed a lot.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not require.
Yes, his antics were to delay the trial. He knew he wasn't innocent because I mean he said in the investigation, not investigation, but the interrogation. He basically admitted or tried to admit that he didn't do it, but he said it in a roundabout way where, he told on himself. Oh, I don't want anybody to get hurt, man. Some kids was hurt. So you clearly did something.
That you cite to that I could even interpret as a request for relief.
Be right back.
So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork. I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note
so
that for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
I believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the sheriff's department to let Mr. Brooks know to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason
Mr. Brooks?
I would just want it.
Hold on, I'm going to
for the
mute you
record.
for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm
want
not
to correct
asking
the
for a
record because
response,
it's not-
sir. Mr. Brooks?
It's not. It's
Okay,
not accurate,
you're
Your Honor.
interrupting. Hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me. And then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise.
So you're not bleeding because you wiped the blood off on your pants. And so you're not bleeding, but you want to delay proceedings so you can get your boo-boo kissed by Bubba and them. Okay, then. I'm gonna be quiet. I'm gonna be quiet.
That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
Okay.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time. But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm going to mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start.
Can you hear me now? Can you hear me now? I'm still muted. Okay. Okay. Awesome. Thank you.
Of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Ooh, somebody's upset, baby.
Give Mr. Brooks one more opportunity to change out of his orange jail uniform. Excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right.
You are present.
I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
And I think Mr. Brooks needs his objection signed.
We'll make sure he has it.
Thank
you. He is very confident in his stupidity.
Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions.
He's looking like this some bullshit. This some bullshit.
Lunch hour or not, the state should be potentially prepared.
She ain't listen to me. Am I muted?
Its opening. Mr. Brooks, if we do get to that point where the state is giving its opening and you have an objection, you need to write down the objection.
Write it down.
In addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to, in addition to holding up your sign. That's the procedure that we will follow. All right, now we're on a short break until the jury comes in.
Hey, bitch, white bitch, objection, white hoe, what, look, hey, where you going? White bitch. You don't see the sign? Oh, that's some bullshit. Y'all playing games. I'm waving the sign and y'all don't even pay it no attention. Like what type of shit is this? Y'all ain't got no integrity, man. Take this shit. I can't. A black man can't catch no breaks in this country, in this state. All this, y'all racist white folks doing all this bullshit to me, and y'all can't even look at the fucking objection sign. What I got to do? Do I got to run over somebody else? And I got to run over your kid too to get some attention? Why y'all not paying me no attention? Man, you know what? Fuck it. I'm just finna I'm just gonna stand here. Y'all gonna do what the hell y'all want to do. I'm just stand here. I'm just stand here. Because y'all don't care about what I got to say. No way. Y'all don't like me. This is racist. Just racist. Racist bullshit. I don't appreciate it at all. And people need to know my story, my struggle. My struggle. Y'all doing all these political campaigns. Y'all trying to do A, B, C, D. And where's that leave me? Look at this. Mahatma.
Or speak with the jurors. Do not listen to any conversation about this case.
Oh yeah, we're gonna
do not research
that. She talked for a long time.
Have been proved as to count 25. All of the instruction numbers are left in.
Bitch, I know you see me.
There was a discussion on the record yesterday about access to jury instructions, even though this court is under no obligation, and explained that to him during the colloquy regarding the waiver of counsel.
It just shut off.
Do you know if anything what I said was picked up?
That's right. It's pure biasness. It's biased. I can't hear.
Looks like Mr. Brooks has put on the headphones and they're testing them to see if they are working. I don't believe he had those on prior to the break.
My own show, he had been looking at about 10:54 a.m. and when we broke for lunch, it was about 11:54. So it was about the last hour of the morning session. He was not wearing the headphones, Your Honor.
Thank you.
So that's why Darrell don't like opera, because she's like, yeah, you know, at 8:55 to 9:55, he didn't have his headphones on.
That can be provided if that one is not working.
He looks so stupid. Like a reject from Oz.
Looks like a new battery pack, charger pack for that was provided. It's not the headset, but the attachment that gets charged. So hopefully that works.
Listen, how hard is it for your headphones to where you plug the shits in and then they come on? Like, how hard is it? I submit to you the idea that he lying and he is trying to delay.
Mr. Brooks, I am offering you an opportunity to come back to the main courtroom. Would you like to do that? I'm not sure why we're not hearing him very loud at the moment, but can you repeat that again?
I say yes.
You'd like to come back? All right, we'll have you brought back then. Thank you.
I know that hurt his pride to agree. Oh, I know that hurt his pride. I know that had to hurt. All right, here we go.
Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes.
There he goes,
So
wiggling
it's
and
his
twitching.
choice. He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
They never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Who gives a damn?
Clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption.
That's what it's been done
If you
for.
have an objection,
Hey, Beverly,
write it down
the Texas
on a
chick.
piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions, or the filings that I filed on the 3rd?
Where did filings from the 3rd come in? Let's listen again. Let's use our thinking caps in our ears, and let's listen to see what she asked.
I'm clear, are we talking about
I'll write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury. Because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
just so I'm clear, are we talking about objections to strictly jury instructions, or?
So clearly he understood what she was asking for him to even say the correct answer. So we're talking about the jury instructions, or this other shit that you didn't say nothing about, but I want to talk about.
Or the filings that I filed on the 3rd.
I'm not addressing those at this point,
I
sir.
was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
To my jury
I'm talking
instructions.
about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
I'm
Shut
not
up.
addressing any of those filings. I've previously addressed those. It may not be to your satisfaction, but,
Remember what you said, to be honest about those.
and I'm not going to repeat myself.
There you go.
So the record speaks for itself.
That was the correct
Your
answer.
objections in those filings, to the extent, whatever they are noted. They're part of the record. And they will be available for you at a later point in time, should you be convicted and on appeal, to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings.
I haven't had an open
So you will
statement
have an
yet.
opportunity after the state presents their case in chief and they rest, to then present your case and to
Dyke
present
skills what?
evidence that's relevant to
Oh.
the issues before the court and the jury. So
Yeah, me and Dykes go back. We go back like babies and pacifiers.
I'm not going to go through any further on what that means. That would be
I know,
for
Jeff.
me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I don't understand, though, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69. And so I still have a ways
69.
to go. My intention would be to finish with the preliminary jury instructions take a short break for all, including the jurors, and then come back with opening statements.
You're right, Glenn.
And you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over here.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand
Here we go.
how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That still
No,
has-
there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr.
bring
Brooks,
up
I'm going to
subject
bring the
matter
jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you
He has never given an articulate, coherent argument ever. Nothing. Paisley makes more sense. And Paisley doesn't talk. And I understand
you
Paisley.
start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
Your objection to my characterization of that is noted.
I would like to make a motion for finding the fact in.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored and granted.
That is inaccurate
And
because
you,
I
Mr.
altered
Brooks,
the
don't
contract.
interrupt me.
Shut the
okay?
fuck up.
That's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It's not my intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm not
all right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that,
So for those of y'all who saw the Sarah Boone hearing today, she was making these exact same arguments that she does not understand the court proceedings. And she was trying to get a co-counsel or assistant counsel, and she was told by the judge, negative ghost rider. So this is the prime example of, if y'all want to go pro se, or pro per, whatever you want to call it, go for it. But you can't bitch and complain about all your attorneys doing A, B, C, D, and E, and F to you. And so then no attorney that you get wants to represent you. All of them quit. So now you're left by yourself, and you have this monumental trial to get through, but you don't understand anything. And then you think that you're going to go to court and lobby all these complaints and all of these statements, and I don't understand. I need you to help me understand. I'm just seeking to understand. That's not what they're there for. They're supposed to be the trier, the judge of the factual basis of this case. They make determinations, legal rulings. They don't do law school on the fly. We're not the Kardashians. You can't just, because your dad got OJ off, then you get to be, grandfathered into a legal career. You got to know what you're doing. And you got years and years and years in life and the death penalty and on the line, and you gonna do this to yourself? Bruh, bitch, why?
Mr. Brooks, that's another interruption. You keep going. Stop.
Shut
I'm
up.
seeking merely to understand, Your Honor.
Shock
I don't
him.
understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the,
She's like, I can't
subject
do it.
matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you.
So what are
The
you
fact
gonna
that
say?
you are doing
What she should have said was the fact that you are shackled to a table in jailhouse clothing is your subject matter jurisdiction. We have subject matter, we have physical jurisdiction over you, bitch. So that's it. Motion denied or motion granted. Shut the fuck up and sit down.
that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
That's
If
correct,
what you
ma'am.
want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So
I
at this
respect-
point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek to
interrupting me,
understand.
sir.
I'm not. I was
If
in the
you
middle
have
of
an
saying
objection, write it down.
something. I thought that applied to me being.
It's
from
applying right
another-
now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All
a
right,
reason why?
I'm not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's
All
inaccurate,
right,
Your Honor.
some of your
You know what? His behavior tells me that he has never held a real job in his life where he had to actually go somewhere and focus on something and then realize that I just work here from 9 to 5 or 8:30 to 4:30 or whatever time. I just work here and I ain't got to agree with it, but I'm just going to go with it because, I just want my check on Friday. I can tell he has never held a real job because no one that has had a job or has successfully made it through school does this. We can't do this. Can't do this. None of us would have nothing. I mean, even just to do simple things like to drive, you have to have concentrate. Well, I mean, what we see that he didn't focus or concentrate. So let me just continue.
Your filing,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filing do not require a specific line by line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Negative.
Madam Clerk, have the jurors brought in, please.
What you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit.
It does not have merit.
Tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting.
You're a Brooksaholic, Rosalind, just like all of us. Embrace it. This is a safe space for all Brooksaholics.
Purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the waiver back in the way that I felt that it should be altered. And you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you.
Right.
That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely
you was playing word games. You understood everything, and you understood. And just because you wrote "don't understand," but I'm aware, okay, well then, bitch, you understood. Shut the fuck up.
Really, just clarification, Your Honor. I don't understand what is going on.
I don't understand either.
It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
Do you understand when I tell you not to interrupt me? Do you understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
Get him, Judge.
I still would like to ask questions, Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect.
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr. Brooks, the jury is in the courtroom.
I understand that.
You continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr. Brooks,
he doing this in front of the jury. This is a first time coming in the courtroom and seeing this. This is day one. But he thought that he's going to get them to nullify after he'd been carried on like a dumbass for all these weeks. Stop it.
You can stand. You need to be quiet.
Shut the fuck up.
Thank you. Mr. Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand.
Mr. Brooks, final warning.
I'm seeking to understand. It must be some clarification.
Mr. Brooks, I want you here.
I want to be here.
Stop interrupting me.
You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, can I?
Ladies and gentlemen of the jury, I'm going to continue with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
Yes.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree reckless endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty.
Oh, he hates being ignored. And for him to just have to stand there when she's doing all this reading, you know, he was cursing her, and he, in his mind, he was running her over multiple times. You can see he running her over right now in that raggedy piece of shit car. You know, that's his modus operandi is running people over with his car. You know, we not shoot. Well, I mean, then he shot at his nephew and pulled the gun out on his mom. I don't know. I'm just trying to get through this. I know her mouth. She got to be tired. Look at this. Look at this dumbass.
That the defendant knew or had reason to know that the vehicle he was operating first degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death.
Remember when we were watching this and this kept going on and on and on and on? It was like, oh my gosh, this bitch did all of this mess.
I'll take these in order. The first is a note from Mr. Brooks that was handed to Deputy Whittier.
Oh, hold on. Let me slow this down. All right.
At about 12:05, it says, I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next.
Are you making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding of fact.
Your request is denied. The next.
May Your Honor explain why.
Mr. Brooks, I'm going to go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making an error, Your Honor.
Mr. Brooks?
Shut up, bitch. I know that he had a ID. I don't think, now y'all correct me if I'm wrong, but I don't think that he's had a license. Like I said, let me know if I'm wrong.
I'm not going to have a debate with you right now. We are continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52 p.m. says, are you making a judicial determination? I'm not allowing my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum.
Them rules don't apply to me, bitch.
And courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by your honor? That's a valid question.
Mr. Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
Baby, bye.
I can't even get these admitted into evidence.
That's Mr. Brooks. I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand.
Whose fault is that? Who should I feel sorry for you because you decided that you wanted to go on a suicide mission and then decided, on the way there, I don't understand what's happening. I don't want to do this. I don't want to die.
But that doesn't mean we're going to have a discussion or a debate about what it means, because we're not going to do that.
The rules that you said.
So the bottom line is, I don't feel, Mr. Brooks, stop talking. I was
following the rules when you said.
Did you hear him? He said no. She said, Mr. Brooks, stop talking. She said no. He said no. No. No, ho. No.
That I had to make all
and you
objections.
did, and I'm going through them.
Writing.
So give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All
Brooks, I'm going to address the next one. So please pay attention.
What you were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr. Brooks, again, you have the right to present a defense, but that right is not unfettered. That right, Mr. Brooks, you are interrupting me. Stop.
Because you're talking about
because you're purposely doing this, so I can't get my reasoning out. You make it incredibly difficult.
I'm not referring to the Sixth Amendment.
Mr. Brooks.
To the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom.
She is singing, "Take me to the King. Take me to the King. Don't have much to bring." That was the look on her face.
Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making.
Baby, look at her face. Look at her face. She's just like, Jesus, give me strength. Give me strength. I'm trying to pull out my Wonder Woman whip, and he is beating me down. He is beating me down. Look on her face. Oh, she tired. She tired.
A judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial.
Mr. Brooks, you also have an obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence. That's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. Okay. You both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right now.
You also accepted the terms of the paperwork that I filed out.
Mr. Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not
or engage in any type of of that
You're not
kind of
entering into
dialogue,
any
because
contract.
that's what you're claiming through some
No,
of
I'm
these
not.
filings,
I'm
and
not
you've
claiming
said that
I
previously.
am not claiming that, Your Honor.
So,
In any way, shape,
Mr.
or
Brooks,
form, do
I'm
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, you please, I'm asking you to follow the rules of civility. Simple rule, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's
So,
being asserted.
Here's
on my
what's
end.
happening, sir.
All
I'm telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. But and
this
then
is
I'll bring
something
you
that was
back when the
filed, though.
jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing this court with
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First
Remove me
Amendment
then.
right?
I'm
Or
not
are you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination, sir.
So you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights.
Judge Darrell, you dumb bunny. You don't know the amendments. You hadn't read your Constitution. Sure, you got a law degree. You went to school for this shit and you were judge, but whatever. You know what? Judge Darrell is a DEI hire. That's why we don't have to listen to her, because she's a DEI.
Are not unfettered.
Yes, they
Your
are, Your
rights-
Honor. You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
your First Amendment in some respects is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have?
So it
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And
Honor,
it doesn't mean you get to put forth any kind of evidence that you want in
Your
front
Honor,
of a
am
jury.
am I
What
being-
it means, sir,
am
is
I being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeit his right to be
I have
present as
not
I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your
everything.
Now, y'all hear, do y'all hear that she has said since day one, when she kicks him and puts him in timeout, that he has to pledge to her that he is going to follow the rules of decorum. Now, remember, at the end of the trial, after he did his Fort Day and his Hail Mary throttle body gambit, and he's being sentenced, he was like, you never had them ask me to have some specific words and phrases. You never had me do that ever. Yes, you did, bitch. Day one.
I do not agree to it.
Of the record to reflect
Right.
I'm stepping off. The
Oh boy. All righty. Let me see where we at now.
attempting to make a record of what is happening and decisions that
Lord.
I am making.
Hold on.
And after repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings. The record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because, frankly, it can be difficult to keep one's train of thought when you're consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple. It is disruptive. It disrupts my thought process. It disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections. You wrote them all down. You followed that procedure. I told you I would take those up after I got through the jury instructions. I was attempting to do that, but then you started in with your antics, with your interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not making any threats or anything like that. That certainly would take things to the next level, in my opinion, but it's not necessary for this court to make a finding that your behavior is disruptive. And this obviously comes on the heels of your conduct this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll once again rely on the decision in Illinois versus Allen, 397 U.S. 337, a U.S. Supreme Court case from 1970 on the options the court has constitutionally when faced with a disruptive defendant, someone like Mr. Brooks, who cannot conduct himself consistently with the decorum and respect that is inherent in the concept of courts and judicial proceedings. The consistent interruptions are not only disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks of all court proceedings. I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court. And therefore, he has forfeited his right to be present while we discuss all of these filings. I'll also make a finding that the technology that we are utilizing here today, we are Polycom to Polycom, the audio and video have been working very well this afternoon. No issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. Gives him the opportunity and the ability to meaningfully.
Bitch, you see me? You see this blue sign?
By exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say. But what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do that with him in the other courtroom. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response, and I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E, at 654 Fed 3rd 753. It's a Seventh Circuit case.
Write this shit down, Darrell. Write it down.
Language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics. And I believe Benabe and the language that you cited is directly on point. And that is why I can simply
look, his mind working. Look at him. He's a little diligent little worker bee.
And or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being moved upon.
It's the most work he's done probably in his life.
Then the second filing, we heard him discuss at length, so I'll just have the state
Cassandra.
respond to that, and that was
Nice
his
to
claim
you.
that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and there is, they can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
Mr. Brooks is raising his objection sign. Since he was given an opportunity to address this previously, I'm not going to give him further opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial.
Oh, she said it again.
In addition, any of his specific objections should be brought by motion. Even if that's an oral motion, it should be based in law and fact and request specific relief. His filings make claims that have no underpinning in law or fact. It's really conclusory. This court is under no obligation to address, conclusory statements by him that are not properly made, both in form and in substance. This record's replete with references and instances of Mr. Brooks just simply spouting various amendments or theories without their...
Yes, thank you, Cassandra. Make sure y'all smashing that like button. I really thank and appreciate you guys.
No constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true.
And I think that's a problem, the way that they are explaining it, because if you're stupid, you don't know what fettered or unfettered means. I think that she should have said something like, it's not absolute. Maybe that would have been something that he would have he's lying anyway, so it doesn't matter. Doesn't matter.
In a court of law where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum, he can present his defense. He has a right to present a defense, but his rights to do that must comport with the law, and that law is what I've already pointed out.
Translation: he has a right to have a defense, but he does not have a right to raise all types of fuckery facts in here.
So I'm not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this.
And she's a
we'll
judge.
move on to the next one.
I.e. judicial.
That is and he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. Here's what I will rely upon: the Beneby decision from the Seventh Circuit, that these are just various arguments raised by sovereigns that have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves, how he wishes to be addressed. This court will refer to the name that is on the information in this case. That is the official charging document. And that is what I will do. If I mispronounce his first name at times, my apologies. I know I said it, his name repeatedly throughout those jury instructions. I know when I first had hearings on this case, even his own attorneys referred to him as Darrell. It was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right. Or words to that effect. I may not have the exact quote, and I'm not quoting him.
No, you
but
didn't. I know you didn't admit to your name, and you gave her the correct pronunciation. I know that you didn't. I know you didn't.
For me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further. I frankly, his last...
Jeff, he got to go to Gen Pop at some point. He's going to Gen Pop.
To do that, and I never agreed to or consented to a quote not guilty quote plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, the defendant would need to go through the plea questionnaire waiver of rights form and have to knowingly, freely, voluntarily, and intelligently waive all of the rights that go along with that. In other words, this court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties. I will note Mr. Brooks continues to have the objection sign raised. The other thing I want to make a record of, we did have the civilian jury bailiffs check with the juror that was identified.
Yeah, they all go to Gen Pop eventually. I mean, remember, Jeffrey Dahmer ate people, and he went to Gen Pop. And what happened? He got his skull cracked open. Hey, Lady T.
Objection sign, Mr. Brooks. You know, I frankly did that for your benefit. You raised what really is an important issue, and I appreciate that. I was
Look at him talking. Now, bitch, I don't want to hear that shit. Cut that shit out.
He's got a point
Cut it
there.
out.
He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that. That's why I backtracked a little bit, said I would look into it. So I'm not sure why you're objecting at this point. I took an important piece of information that you were relaying, and we had it, in this case, it was confirmed that the juror did not attend any proceedings, and so that will address your issue with her. All right, now the next step would be opening statements. So, Mr. Brooks, you have demonstrated in the past, and I'm going to unmute you, that when the jury is present, you are able to maintain civility, show them respect, show the courts and the process respect and dignity. I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity.
I know you're holding up your objection sign, but I just don't give a fuck. I just don't.
To come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
Come on,
So
bitch.
I'm on the record.
You are. If you would please address my question.
Now you know I ain't gonna do that.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you, I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules when the jury is present. The jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof. And then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm gonna get sent out.
Mr. Brooks, it's
Answer the
your
damn question.
conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
You're
not
saying
Lady T, she is.
do that, then you run the risk of once again forfeiting your right to be present.
you say that even though I never consented to being taken out. You say that everything
Oh my
is
God.
about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand,
Oh.
then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive.
And I'm not doing that.
And I don't understand why everything
nice
I say
guy.
has to have some type of disruption title to it. It's even been put on record numerous times.
Yes. Let me just take a couple seconds out so I can gaslight you, Judge. Okay. Y'all are saying I'm being disruptive. It ain't intentional, even though I won't shut my pie hole. I'm gonna keep on talking. But hey, y'all are putting this label on me that it's not true. It's not true. I just don't understand. And I'm going to continue to interrupt you over and over and over to let you get a word in edgewise, but I'm not being disruptive.
With inaccuracy. Even what happened today. Nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me.
This is so ironic that you would talk about this baby bruise, bandage bullshit when you literally ran over people and killed people. And they've had significantly more hardship and physical damages and injuries than this stupid shit you talking about. And it is very disrespectful for you to talk about your bruise on your little finger and your bruise on your arm and your cut on your finger, and you killed a 7. How old was Jackson? 6, 7. Missy was 8. An 8-year-old little boy. So I'm supposed to be concerned about your boo-boo when you unalived people? Are you kidding? Boy, come on, man.
I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me.
We'll see, there's a reason for that. She's a judge and she's not in jail and she's not in custody. She is not the property of the state, such as yourself. So that's one reason why she doesn't have to answer your questions and you have to answer hers, because she's the court making a determination about whether or not you should be allowed to come back into society and potentially harm and injure more people. So she ain't got to listen to you. What else I was about to say here? I don't even know what I was about to say. I'm old, y'all. I was going to read Glenn's comment for those of y'all who aren't looking. So Glenn says one of Darrell's victims had to have 23 surgeries just to talk and walk again. And he's talking about a bruise. Exactly. Multiple surgeries, trauma, PTSD. Those people told you told us in their citizen statements, their impact statements, all the things that they are concerned about, how just seeing a red vehicle freaks them out and they haven't been able to sleep. And these parents who you ran over their children, and like the Miss Urel, 5 of her kids is injured and you don't know if your child is going to make it. And they've had for you to even make these statements, it's just, wow. Yo, baby mama Erica, you ran her over that day and she got a boot on the foot. And you're talking about a cut and a bruise. Oh, he gonna be a lot sore when he go to the when folks get to him, when he go in Gen Pop, he gonna be a really sore. And I can't wait.
Where's the give and take? It should be fair.
Give and take.
I'm not asking for legal advice.
Yes, you are.
I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand.
You want to go to law school on the fly. You want to have night court law school. And for her to answer any of these questions about why is this and why I don't understand this, she's going to be giving you legal advice because you're going to be quiet.
I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Brooks,
no one cares,
I'm not
sir.
gonna go through this with you
We don't
again,
care.
where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right. You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings.
I am not obligated to answer questions.
You made
when
those
you ask me
filings.
questions, I'm going to mute him.
Mute his
I am not
ass.
obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are based in law and fact. I'm obligated to address objections, for example.
So what the fuck am I doing here? What am I doing here?
Or evidence or questions posed to witnesses. But I'm not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since I gave him 2 opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding.
You see how he's gesturing and everything and talking while she's talking, muted. This is just like when you're a little kid and your mom or your dad says something to you, and then they tell you to go to your room, and you're just like, okay, fine, I'm gonna go to my room.
Will remain.
I don't care what you say. And your mom is like, what you say? I heard you.
It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask.
That dirty diaper.
And I just wanted to make a record of that. All right. Then we will have the jurors brought in, and then the state can then proceed with its opening statement.
And Kathy, they said that in the colloquy that the Wisconsin does not have standby counsel, that you're going to either have the counsel that's here or you're going to represent yourself. Literally said that multiple times. Painfully simple slow. She went over that colloquy very thoroughly to make sure that he understood, and that bitch understood. See, he should have did this in Fulton County in Georgia and had Judge Glenville. He could have got away with this trial still, lasting. We could have still been on the state's case in chief, fooling with the Judge Glenville. Come on, man. How is that right? This ain't right. Y'all know it ain't right. You know it ain't right. How y'all gonna do this? Y'all know that ain't right. This ain't right. Y'all know I ain't waived no counsel. But you know what? I don't give a fuck. No way. It don't even matter. Shit. I don't consent to being called that name. He practicing his little speech. I don't consent to being called that name. I'm a third party intervener. I gotta go over all of this because I gotta get the right phrase. That right phrase is gonna get me out of here. I know. Y'all can't prove I did it. Y'all can't prove I did this. Y'all are trying to set me up. Y'all trying to get me hemmed up on some bullshit because you trying to ruin my life. You trying to ruin my life, and y'all is not gonna ruin my life. Y'all not gonna ruin my life. I'm being in jail for the rest of my life over some shit y'all can't prove. That wasn't even my car. Magical Marcus and Secret Stephanie was in that car. And fucking Erica, her ass was drinking. And she was in the car too. Y'all know y'all didn't see me. Hell, y'all, what the fuck y'all mean? This some bullshit, man. They doing all of this shit. It's some bullshit. They know this ain't right. But they doing this shit on purpose. Ain't nobody but one black person in the room. Look, it's only one black person in the room. It's wrong. This is wrong. This is wrong. Y'all always just doing stuff. You know, you're not giving nobody the benefit of the doubt. I'm supposed to be innocent until proven guilty. And that ain't my name, no way. That's in all caps. I can't answer to that. It's in all caps. That is not my name. Oh, look, it had all these white folks come back in here. Ain't a black person here. Just wrong. Y'all got me standing up here. It's cold in here. I'm trying to hold on to my balls.
All right, at this time,
because they're going to get taken.
We'll give the parties the opportunity to make opening statements. Does the state have an opening statement?
Yes, thank you.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead.
Whatever.
Middle.
When we do that, make sure we confirm it should transmit, but we'll make sure it's transmitting over there as well. And if that's okay, if it happens, we may lose video of Mr. Brooks for the time being, as the state is using what appears to be a PowerPoint. Just confirm with me, Deputy Wittig, that when it starts that it is able to be viewed and heard over there. Go ahead.
It was a cold.
They can't see it. All right, hold on.
Yeah, Zach is cute. And I did some research. His wife is very cute too. She's a doctor.
All right, let me do this. No one needs to leave. We're going to go off the record though, so that I can set up another way to do this so that there's a share screen capability. Okay.
He had laid his hand.
Here we go.
Replaced it with terror, family, normal. There were dance teams, high school marching bands, local community groups, local businesses, all making their way down the parade route. The streets were lined with friends and family members and neighbors, people there to soak up the atmosphere. Kids ran into the street to grab candy from the people who were throwing it from the parades. It sounds corny, but I think you'll see from the videos, there was a true sense of joy in the air.
Yeah, that's my Jason Statham.
Darrell Brooks killed that joy. Replaced it with terror, trauma, and death. The evidence is going to show that Mr. Brooks left behind a trail of carnage and chaos as he made his way down Main Street through the parade route. The evidence will show that he left that crime scene, created that crime scene, in fact, because he was fleeing from another one.
There you go.
One where he had laid his hands on a woman and where police involvement became inevitable. So as he careened down Main Street, swerving from curb to curb, hands glued to the steering wheel, eyes fixed on the road in front of him with a silent rage on his face, he hit the gas with his red Ford Escape and used it as a battering ram over and over again, striking men, women, and kids.
Y'all saw him roll his eyes.
Gas with his red Ford Escape and used it as a battering ram over and over again.
He's rolling his eyes. Yeah, Zach is running to be a judge.
Striking men, women.
So disrespectful.
In the end, Mr. Brooks killed 6 people. He injured dozens more and left a permanent scar on this community. We are going to present evidence to you over the next several days in chronological phases, in order of events, from start to end. I'm going to take a few minutes. I'm going to lay out for you the table of contents to this story. We're going to set the scene with Sergeant Dave Warner from the City of Waukesha Police Department. Sergeant Warner was the highest ranking police official working at the parade that day. He was the incident commander for the Waukesha Christmas Parade, and we are going to, with Sergeant Warner's help, take you through this, which is the first of 3 maps that we will refer to repeatedly throughout this trial. This map depicts the area that we're going to be talking about over the next couple of days, the parade route. Now, for those of you not entirely familiar with downtown Waukesha, this is going to look like a bunch of gibberish, but once we get going and we repeatedly refer to these street names and the business names and the groups that were involved in this parade, I think it'll become like a second language to you. Sergeant Warner will describe for you how the parade route ran from, if you look closely at the screens in front of you, the intersection of Main Street and White Rock Avenue. White Rock was a staging area for the parade groups and floats. And they made their way southeast on White Rock until they came to Main Street, and then they would make a right turn and head southeast down Main Street through the parade route until the very end as it wraps around to the south and runs into Wisconsin Avenue. The parade route then would continue to the east, making a left-hand turn on Wisconsin, but nothing really happens on Wisconsin Avenue. You're not going to hear any testimony about that. As you can see from this map, it depicts or represents each intersection where a squad car or a police officer was stationed. They're denoted by the little badge shields in the intersections. If you look closely, you can see little red lines, and Sergeant Warner will describe how those represent the barricades that were placed at each intersection for security and safety purposes. Once we've got that established, we're going to move into the first chapter of this story, and you're going to hear about the origin of Mr. Brooks' rage that day. A violent domestic argument with Erica Patterson, his former girlfriend and the mother of his child. Erica Patterson is going to testify either today or tomorrow, hopefully today. She's going to tell you that in November of 2021, she was staying at the Women's Center, which is a shelter here in Waukesha. And on the day in question, November 21st of 2021, the defendant showed up in Waukesha in his red Ford Escape that she knew he drove, and he argued with her, and he harassed her, and he punched her in the face. And the thing about a swollen eye...
Oh, so we laughing. We laughing that you punched her in the face. In front of the jury, y'all.
Is it's tough to fake. You're going to hear evidence about how after, let me back up. You're going to hear evidence about how the defendant took Erica Patterson all over town that afternoon. From Frame Park, across the river, up Barstow Hill, back down to Frame Park. And at some point, after she was struck, after she sustained that injury, Erica called her friends because she needed help. And she had no one else to call. One of those friends is Corey Runkle. You're going to hear from Corey on the witness stand in this trial. Corey's going to say that she was Erica's roommate at the Women's Center. She had known Erica for a few weeks and they had grown close. And when she got the call from Erica that Erica needed help, Corey immediately responded to help.
Y'all see how serious he is now that we're talking about Erica, because Erica, that's his kryptonite. So anytime Erica comes up, he gives full attention to Erica and nothing else. The rest of these people, who cares? The little 8-year-old boy that I killed and ran over, who cares about any of that? Erica.
And she ended up finding Erica and Darrell Brooks in front of the White Rock School. If we go back, the White Rock School is on White Rock Avenue. It's on near the top right portion of the map. It's just south of Frame Park. And Corey is going to talk about how she found Erica and the defendant at this location, and she got into both a physical and a verbal altercation with Mr. Brooks. That altercation is captured on surveillance video, 2 surveillance videos actually. You're going to see both of them. You're going to see how the defendant was reacting that day. You're going to see what he looked like, what he was wearing, the red Ford Escape that he was driving. You're going to see how the defendant reacted once Erica's friends showed up and he lost his physical advantage over a woman. Erica and Corey will also testify that at some point during this scuffle, the police were called. And you're going to see a separate video, a squad video from the responding officer that shows just down the block, there was a marked squad car with its lights flashing, marking the entrance to the parade. Something that people in front of White Rock School would have seen. So the evidence is going to show that the defendant must have known once things got loud and once there was more than just him and Erica on scene, the police were going to show up.
He knew he fucked up.
So he took the coward's way out.
And ran.
You're going to see him in the video get into the driver's seat of that red SUV. Corey and Erica will tell you that no one else was in the car. And you're going to see him pull off on White Rock towards Main Street. You're going to hear from law enforcement officers who were positioned along the parade route. The officers who made their initial contact with the defendant, the first ones who tried to stop him. And the first one is Detective Tom Casey, the lead detective in this case. He's sitting at the state's prosecution table right behind me. He's going to tell you that he was working that day as security for the parade. He was working at Main and White Rock. He's the first law enforcement officer to come into contact with the defendant during this incident. Face to face. Or I think better describe it as face to windshield. He tried to stop the defendant, but there's only so much a man can do against an SUV. But he's going to tell you that he got so close, he got such a good look at Darrell Brooks's face that From that witness stand, he'll be able to say to you definitively, Darrell Brooks, the man in orange on the video screen, is the man who was driving the red SUV in this case. You're going to hear from a few more officers. Officer Bryce Butcher and Officer Sonia Schneider. They were positioned at the intersection of Main Street and East Avenue, just a little bit further southwest in that map. You're going to hear them describe how they saw this red SUV approaching. They quickly realized it was not part of the parade. They quickly realized this was a problem. There are people, children in the street, lining the street. And so they jumped into action. They tried to stop it. As the SUV started barreling towards them, Officer Butcher, again, tried to get in the way. He put himself at risk trying to get in front of the vehicle. Couldn't stop it. Officer Schneider tried to redirect the vehicle up Buckley Street, making a right-hand turn. She'll tell you, and you'll see in the video, there was room. There was space. She couldn't do it.
I wonder, does he sit in his cell at night and think, man, why did I do that? Do y'all think that he has those types of thoughts, or do you think that he just thinks that he's the victim and this is all Erica's fault? What do y'all think?
The defendant blew past her. And that's when the screams in the police radio start. You're going to hear from Jim Hawkinson, a battalion chief for the Waukesha Fire Department. He's going to tell you about the massive scope of the emergency response to this tragedy. He was in charge of the fire department that day. He's going to tell you about all of the units that had to respond to the scene, the massive amount of resources needed to triage and treat and transport all the victims. He's going to tell you about the response from other communities in Southeast Wisconsin, the mutual aid call that went out, and all the other communities that came to help out. He's going to tell you about how Waukesha Memorial Hospital, just up the hill from the parade route, quickly reached capacity. And so everybody had to be diverted to other medical facilities. We'll transition then into the next chapter of this story, and you're going to hear from some of the people whose lives were forever changed by the defendant's terrible decisions that day.
Oh, you know, he don't care about that.
But I'll tell you right now, you're not going to hear from all of them. It wouldn't make sense. It's not necessary. We intend to present the evidence to you in an efficient and streamlined way. We will elicit testimony and introduce exhibits that cover every element of every single criminal charge in this case. But our goal is to avoid duplication of evidence and to avoid undue hardship on the victims and the witnesses who have already suffered so much. So the first witness in this part of the trial that you're going to hear from is Nicole White. She's the very first person, aside from Detective Casey, who was struck by the defendant on that day. She's going to tell you, as we look at this second of the three maps that we're going to repeatedly refer to, that she was marching with her coworkers and friends with Remax. You'll recognize the float, I think, in the videos, because just like the commercials for Remax, there's a giant hot air balloon that shoots fire out of the basket, which is pretty cool. And she's going to tell you she was marching with her friends and her coworkers when, without any warning, she was hit from behind and knocked over. You're going to see video of that.
From behind.
Nicole White has a special significance in this case because, as the first person who was struck, she represents the point in time when Mr. Brooks was legally required to stop. You heard the judge read the hit and run jury instructions. And to summarize, in Wisconsin, anybody who's operating a motor vehicle who's involved in some kind of accident, they have a duty to stop, to investigate, to exchange information. Not only did Darrell Brooks not stop, the evidence will show that he sped up. The evidence will show that as his body count increased, so did his motive to get away.
No fucks given.
Nicole White, I think, is a good point here for me to explain to you, or to summarize for you, the charge of first-degree recklessly endangering safety. Now, again, the judge read the law to you all morning and
now, Darrell, this applies to you. You need to listen to this because you don't understand the nature and cause of the charges. He's about to explain it to you. Listen.
a lot of the afternoon, and she's going to read it to you again at the end of the case, and you're going to have a binder with all these instructions written down for you, so you do not need to memorize them, okay? But we're going to talk about first-degree recklessly endangering safety. It's a crime where it's committed by someone who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Let's talk about what the state's not required to prove with recklessly endangering safety. Not required to prove injury. This was a conscious decision in our charging decision. We're not going to get into medical records. We're not going to talk about the details of witnesses' injuries because it's not relevant, except to the extent that it proves that they were endangered and resulted in injury. But we don't need to get into who was hit or how hard or how long they've suffered. We just are going to prove to you that their safety was endangered.
Lord,
So,
what would I ask him?
After Nicole White, we are going to talk.
What would I ask Darrell Brooks if I could interview him? That's a good question. I mean, I would have to try to not sound biased and, confrontational like I hated him. But I would just ask him, like, what the fuck was going on in your mind? Like, explain this to me, please. Or please explain. I want him to explain the magical market story and how he thought that was going to be a believable story that they were going to, be like, okay, you can go. Or why did you think that after all of your jacked up behavior, you thought that the jury was going to be on your side and want to nullify these charges when they have seen you behind the wheel of the car running over somebody with the window down? I just want to know what his thought process is. That's probably what I would ask.
You're going to hear evidence about the first of the larger groups that was affected by this incident, the Waukesha South High School Marching Band. 10 kids in that band got either hit or run over. Here's the first example of our efficient presentation of evidence. You're not going to hear from any one of them. High school aged kids, there's video showing each and every one of them getting run over. So instead, you're going to hear from their band director, Sarah Waymire Aparicio. She's going to come in and she's going to look at some still shots of the video. She's going to identify each of the 10 kids for you. You're then going to watch and listen to the video, and it'll be clear as day who's getting run over or hit. It'll be clear as day whose safety was endangered by Mr. Brooks that day. As we move further down the parade route, you'll hear evidence about the Burris Logistics Group. You'll hear testimony from Kelly Grabo about how she was marching with that group along with her young daughter. You'll see.
That's Grabo. That's the one whose daughter was dressed like Cindy Lou Who. I remember that.
Video of them. They're dressed up like the Who's from Whoville.
See?
You'll see them get hit.
I remember.
As we move further down the parade route, you'll hear testimony about the Green family. They're spectators along the parade route. Charles Green is going to come in and talk about how he was there with his family. He was sitting on the southeast corner of Main and Gasper across the street from Martha Merrill's Books. He'll talk about how his kids were seated on a portable bench, something that you bring to a parade to sit on, and how they got knocked off that bench when the defendant ran into them.
And I think I would also ask, do you even care? Do you not even care about Jordan? Jordan Sparks, Jackson Sparks, Jackson. Did you even care about Jackson? Like that moment in the trial when the medical examiner was talking about Jackson's injuries, were you sincerely feeling remorse for Jackson? I would ask him that question too. I mean, I know the answer is no, but I would still ask him that. Because out of everybody, out of just Jackson alone, because you have a child the same age as Jackson was. I mean, you don't give a fuck about your kids, but whatever. But you was telling about how much you're so close to your daughter. It was the same age as Jackson. So how you can't see 8-year-old child. I killed the 8-year-old child. I would have to ask that question too.
The next point in the presentation of evidence will involve the Waukesha Blazers. I think it's important to point out you can't consider this evidence of each crime in a vacuum.
Good question.
You need to consider the entire incident. Because at this point, by the time we get to the Blazers, the defendant will have already hit or run over 15 people.
God dog.
You'll see in the video that at this point, the defendant has actually increased his speed. And you'll hear from Detective Mike Carpenter with the Waukesha Police Department. He's going to come in and talk about speed analysis. He'll tell you that he's certified to use a software program that basically takes surveillance video, measures the amount of time it takes to travel a certain distance in that video, and calculates an average speed over that distance. And he'll tell you that in video obtained from Bosco's Social Club, which is right in front of where the Blazers got hit, he'll tell you that that video in that area right before the Blazers got hit, the defendant was traveling in excess of 33 miles an hour. There were 5 victims in the Blazers. That includes Jackson Sparks, who was walking with his big brother Tucker. Cut down in the road before he had a chance to put any miles on his soul. Jackson was 8. He died 2 days later in the hospital.
I'm telling you, it's like Jackson is the only person he shows just a modicum, just a small modicum of something. I know it's not remorse and I know it's not care or concern. Maybe it's the 8-year-old boy represents, like, man, I done fucked up, And I think another reason why we are workaholics, I think that we go through this because we're trying to, I know I look at it because I'm trying to see if there's remorse, that I can just see just a flicker of remorse. And I haven't found it yet. And I guess I'm just still searching.
I think this is a good point to talk about the law of first-degree intentional homicide. Again, the judge provided the law to you. It'll be provided to you again at the conclusion of the trial. I want you to take a look at that second element. I don't know what the defense in this case is going to be. In fact, the defendant isn't required to put one on at all.
And he doesn't.
Can sit there and not say a word throughout this trial, and that's perfectly within his right, and you can't hold that against him.
And it would have served him better. Yeah.
And in fact, if he does that and we don't prove each and every one of these counts to you beyond a reasonable doubt, you must find him not guilty. That's the law. But if he does choose to present a defense, if he does raise any issues, I expect that he will likely claim that he didn't mean to kill these people. Take a look at that second bullet point. Keep that in mind as you're watching these videos, as you're learning about how this parade unfolded. Consider whether the defendant was aware that his conduct was practically certain to cause the death of another human being. We're going to move further down the parade route, and the next group after the Blazers is the extreme dance group. There were girls of really all ages in this group, from toddlers being pulled in strollers up to high school age teenage dancers. 15
I think I did.
Victims, 15 people associated with this group either got hit or were very close to getting hit. That doesn't include 2 additional spectators who were watching the parade from the south side of Main Street near the 5 Points intersection.
I agree with you on that.
Right in front of the extreme dance team as the defendant drove through. Girls in this dance group suffered catastrophic injuries. The group of victims also includes parents, grandparents, siblings, people marching with the group, but not necessarily as dancers. You're not going to hear from everybody who got hit. You're going to hear from the two instructors, the two young ladies who were tasked with teaching these girls these routines and marching with them and encouraging them and comforting them after the fact. And they're going to, in the video, identify for you where all these girls are positioned, and it'll be very clear the path of travel of the vehicle as it goes through that group of young ladies, who was hit and who was nearly hit. The next group down the parade route is Citizens Bank. And here we reach the second count of intentional homicide. Jane Kulik was marching with Citizens Bank with her friends, with her coworkers.
And y'all can hear that there's sobbing in the courtroom when her picture came up. I don't know what his end game was supposed to be here.
This is the only count of homicide for which there is no clear video depicting how she died. So instead of watching video, you're going to hear evidence.
Y'all hear the crying.
And from the man who was driving the truck pulling this float. And they're really the ones who are in the best position to observe exactly what happened to Jane Kulik as the defendant plowed through that parade route. And they're going to describe for you how she was struck, how she was run over. The medical examiner will explain that Jane Kulik's cause of death was multiple blunt force traumatic injuries. We'll move further down southwest along the parade route, and we'll learn about a group that was standing in front of the steaming cup, spectators again. Innocent people have nothing to do with anything. You're going to hear about 3 kids who were standing along with a bunch of others along the curb in front of steaming cup. And as the defendant swerved from the left side of the street as he hit Jane back to the right side of the street as he was avoiding the vehicle that was ahead of him, clipped the curb and hit these 3 kids. Then we're going to move in to the next group in the parade route, which is the dancing grannies. This is the deadliest point in the parade. 7 people in this group were struck. 4 of them died. You're going to hear from witnesses, members of the dancing grannies group, who will come in and they will describe being completely caught off guard. They will describe seeing pom-poms in the air. And the next thing they knew, there were bodies on the ground before the pom-poms hit the ground. You will learn about Bill Ospel, who was marching in a support capacity. He was there to support his wife Lola and their friends, the rest of the dancing grannies.
Oh,
just
look.
Walking along the.
Now he's trying to pretend to pray. That's what he does when he tries to disassociate. I'm pretending to pray. Nobody believes you, bitch.
Parade route, trying to be helpful. And as the defendant swerved around the dancing granny's vehicle, which is a white SUV, you'll see it in the video, swerved around the right side. He hits Bill. And the medical examiner is going to tell you that Bill Ospel cause of death was multiple blunt force traumatic injuries. You'll learn about Tamara Durand marching with the grannies. This is her first parade. You'll see a diagram of where she was positioned. You'll see video of her getting struck. The medical examiner will tell you that Tamara Durand, cause of death, multiple blunt force traumatic injuries. You'll hear about Lee Owen, another dancing granny, positioned right next to Tamara, who had just begun one of her favorite routines, walking in a winter wonderland, when she got hit.
Ridiculous.
You'll learn about Ginny Sorensen. You'll learn that Ginny was walking at the front of the group carrying the banner. You'll learn that Ginny was normally a coach for the group. Normally she rode in the vehicle in the back so that she could provide feedback and critique to her dance mates. But she filled in at the last moment today and helped carry the banner. You'll see video of Ginny getting struck. Medical examiner will tell you that Ginny Sorensen's cause of death was multiple blunt force traumatic injuries. You'll hear more speed analysis testimony at this point. You're going to hear from Mike Smith with the Wisconsin State Patrol, who's going to testify very similarly to how Detective Carpenter is going to testify about speed analysis. Basically, he takes surveillance video, this time from Curry Insurance, which is on the south side of Main Street. It shows the grannies getting struck. They measure point to point and measure the time between those 2 points and calculate an average speed over that distance, which is roughly from Clinton Street up until the camera cuts out. They'll tell you that at that point where the defendant crashed through the dancing grannies group, he was traveling at approximately 32 miles an hour. The eighth and final group that was struck by the defendant in this case is the Catholic Communities of Waukesha. This is a faith-based organization.
Yep.
It consists of members of multiple local Catholic churches who got together that Sunday afternoon to spread a little Christmas cheer. There is not great video, and perhaps that's for the best, of this group getting struck. In total, there were 19 victims in this group. In what little you can see from the video, you can see the defendant's taillights swerving from the left side of the street to the right. You can see them bouncing up and down. There are no speed bumps in that section of the road. The next phase of the evidence will involve the manhunt. How authorities found the defendant, took him into custody, and the statements he made after he was placed under arrest. You will hear from Officer Bryce Skolton, who was positioned, if you look at this third of the three maps I referenced.
Bryce Skolton is our Viking warrior.
On the very top of this map, at the intersection of Main Street and Wisconsin. Officer Skolton was positioned at that point to direct the parade route to make a left-hand turn from Main Street onto Wisconsin, to stop any traffic coming from the other directions. He saw the defendant come around that corner. He saw the defendant drive right at him as he's standing in the middle of the road. And as the defendant went around him to the left and went south, Officer Skolton fired 3 rounds from his service weapon. All 3 rounds hit the car. None of them hit the defendant.
I know he's mad about that.
You will hear from
I'm mad at it too.
another police officer who was not on duty that day. He just happens to be a police officer. His name is Officer Ralph Salyers. He's from the Wauwatosa Police Department. If you take a look at that map, he's going to describe to you being on the sidewalk, leaving the parade. He was walking past Les Paul Middle School. He's going to describe hearing a loud commotion. He's going to describe seeing a red SUV with just utterly totaled front end damage coming to rest in a driveway at 338 Maple Avenue. You're going to see video of the defendant in the red SUV pulling into the alley behind 338 Maple. And then a few moments later, you'll see what appears to be the defendant coming back onto the screen and running away from the vehicle, apparently in a hurry, apparently aware that he had done something terribly wrong. You're going to hear from a series of witnesses between that point and the defendant's arrest, where they will describe the defendant approaching them, contacting them, asking them to use their phone. Because he was in such a rush when he ditched his SUV, he left his phones behind.
Oh.
Then you're going to hear from Daniel Ryder, and I think the evidence will show Daniel Ryder really is a good embodiment of the spirit of Waukesha.
That's the one that gave him the sandwich. He had in his pocket. That's be my favorite thing about this trial. Dude had a sandwich in his pocket. Like, who gets a sandwich and puts it in their pocket?
Not knowing what Mr. Brooks had done, Daniel Ryder opened his home to the defendant. The defendant showed up at his front door without any shoes on, with a t-shirt, said he was cold, said he needed to use the phone.
And he was homeless.
Daniel Ryder let him inside. Gave him a sandwich.
In his pocket.
Let him use the phone, and then gave him a coat. And a few minutes later, the police showed up. You're going to see body cam video of that arrest. You're going to hear from Officer Rebecca Carpenter that she responded to that area around where Daniel Ryder lives because of reports of a man knocking on doors. She takes him into custody. He identifies himself on the body cam video. They search him, and in his pocket, they find a key to the red Ford Escape used in this attack. You're going to hear from a series of officers who retraced the defendant's steps that night, recovered surveillance video showing the path that he took. The path is depicted here in the third map that I'm showing you. You're going to hear how they recovered his sandal, his sweatshirt along the escape route. You're going to hear from Detective Jay Carpenter with the City of Waukesha Police Department, and he's going to talk to you about the defendant's statements after he was taken into custody. I'm going to let that interview speak for itself, other than pointing out for you that you will, I think, quickly learn a few main points about the defendant on the night that this happened. He was lucid.
Ugly.
He was aware.
And ugly.
He was intelligent. He was probing for information.
He was doing that.
And he was deceptive.
Very.
We're going to then wrap up with testimony from people who plugged any of the remaining holes in the investigation. You'll hear from crime lab analysts about DNA evidence, about finding the defendant's DNA on the steering wheel of the red Ford Escape. You're going to hear from Wisconsin State Patrol Inspector Ryan Schultz. He's going to testify about the mechanical inspection that he did on this vehicle. In case you were wondering if there were any issues that would have prevented Mr. Brooks from stopping or from pulling over,
what?
Put those concerns to bed.
So they said that in the opening that this Hail Mary throttle body thing is not going to work because we got the guy and said wasn't nothing wrong with the vehicle. Okay.
He conducted that mechanical inspection. No problem with the brakes. The accelerator didn't stick. There were no mechanical problems that would have prevented Mr. Brooks from stopping. Finally, we're going to close our presentation of the evidence, not with a witness, but with an experience for you. You are going to go to a secure location. And you're going to have a chance to see the murder weapon with your own eyes. You'll be able to see that red Ford Escape.
You're going to see the vehicle.
I want to close now with a few points about how the evidence relates to the law in this case. There are, obviously, we've gone through the 6 counts of first-degree intentional homicide. But in addition to those homicide counts, there are 6 counts of hit and run involving death. Those are separate charges. The evidence will support convictions on all of them, all 12 counts of homicide. But they involve the same 6 victims. Another point I want to bring to your attention is that for each count of first-degree intentional homicide and each count of first-degree recklessly endangering safety, if you find the defendant guilty of any of those counts, you have to answer a second question. Did he commit that crime while using a dangerous weapon? And here the evidence will show that he didn't use a gun or a knife to commit these crimes. He used 3,500 pounds of steel, rubber, and glass. The defendant's also charged with 2 counts of felony bail jumping. You'll hear evidence to support those charges, which includes the fact that the defendant was charged with a felony offense in a case in Milwaukee County and released from custody subject to conditions of bail. And then he was charged with another felony offense in a separate case in Milwaukee County and released from custody subject to conditions of bail. And those conditions of bail included requirements that he not commit any new crime. And those conditions of bail were in effect on November 21st of 2021. We have dozens of video clips to show you. You're going to have notebooks and writing utensils while we present this evidence to you. It's a lot to keep track of. And when you go back into the deliberation room, it might be difficult while you're deliberating to remember which video was about which victim or which incident or which group. And so my suggestion to you is that as we go through these videos, you're free to do whatever you want with your notes, but my suggestion would be as we go through these videos, they each will be labeled with an exhibit number. And so I recommend that you keep track of which exhibit number corresponds with which video. That way, while you're deliberating, if you want to see those videos again, you can ask for them by exhibit number. Can't guarantee that you'll be able to see any or all of them, but you can ask. I'm done now. I want to close on one final point, and that is on behalf of the state of Wisconsin, I want to say thank you. You're serving in what is the greatest criminal justice system in the history of the world, and that's because of the 16 of you. It's because a group of citizens, randomly selected, come in and make the final, ultimate determination between guilty and not guilty. That's unique in this world. It's special. And so we're going to go through this evidence. We're going to be mindful of your time. We know how valuable it is. We're going to be efficient, but we have a lot to get through. A lot. And at the conclusion of all that evidence, District Attorney Opper is going to stand up here and she's going to ask you to render verdicts consistent with the evidence, to find the defendant guilty of each and every count. Thank you.
Look at him.
Mr. Brooks, my first question to you is, will you be making an opening statement at this point or deferring until your case, meaning the defense portion of the case?
I will be deferring at this time, Your Honor. I need a little more adequate time to make sure I go over the points that I need to make.
All right, then the court will.
What points? Remember, you were speaking just for the heart, from the heart, and you don't have any prepared speeches, you know, and certain words to say, like the prosecution did. You lie so much.
Honor that request. Advise the jury he's deferring his opening statement until a later point in the proceedings. I am going to just take a short break so I can talk some logistics with the parties to determine whether it makes sense to start with a witness tonight yet. It's 4 o'clock, a little bit after, or wait until tomorrow. So either way, you'll come back because you'll either hear testimony or I'll read an instruction for you. But at this point, the jury may be excused.
Yeah. I think she should have really was like, look, you need to make an opening statement. This should be a lesson for you to prepare. Be prepared tomorrow. But, you know, I think that Bonnie Willis, you know, the YSL, the prosecutor, that's her DA department, she would have screwed this case. Okay.
Minutes on direct. I would ask that you would hear his testimony this evening or this afternoon, Your Honor. He was supposed to have left town at about noon today to take his daughter on a college visit in Kentucky. He's delayed his departure so he could provide his testimony. And if we can get him in and out, he will leave at 5 o'clock and arrive at midnight at his destination. I have a second witness, if the court would hear me. who's here as well. Her testimony probably would also take about 15 minutes on direct, maybe a little longer. No, Mr. Mitchell says no. She has traveled here from Janesville. Her transportation is also difficult. And so she's here and ready to go if the court would indulge those two witnesses this afternoon.
It certainly seems reasonable. Mr. Brooks, my question to you then is, do you want to come back over for the testimony of those witnesses?
I would prefer to. I'm still kind of taken aback by not being able to know exactly how many witnesses are expected to testify, and not being able to turn in my own witness list.
Well, Mr. Brooks, you've been given copies of the witness list. The state's offered you a flash drive with all of the exhibits to streamline what will be presented at trial versus what is in discovery. So you've had ample opportunity to review those. I'm happy to bring you back. I need you to pledge to me that you will follow the rules of procedure and evidence, that you will only interrupt if you have an objection. That objection needs to be founded in law. And then you need to pledge to me that you will honor whatever decision I make so that the testimony of these individuals can proceed within the time frame that the prosecution has indicated it will take. You, of course, will have an opportunity to cross-examine them. Are you willing to follow the rules of courtesy and decorum and the rules of procedure and evidence?
Hell to the no.
From what you explained yesterday, the objections you said have to be like, I think you said like 3 words. Is the way to actually object. So I don't recall you.
I can give you up to a sentence. What I am trying to avoid, sir, are what are called speaking objections. The idea behind that is that you give me just a little bit of information so that I can either make a determination or, if appropriate, send the jury back out so that I can then hear arguments from the parties. Some objections really are 1 word, hearsay, maybe 3 words, calls for speculation, things of that nature. So if you're willing to abide by that procedure, then you can come back to this courtroom.
I can't really definitively give an answer right now to that.
What?
So you're not willing to follow the rules of courtesy and decorum and procedure and evidence?
That's not what I said.
That's why I'm asking a clarification question, sir.
Here he goes.
I was clear in what I said. I don't think I can make that determination right now.
Let me ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
Didn't you just, wait a minute. Didn't she just ask that question and his response was, I don't know if I can do that? Am I wrong? Did I mishear? Y'all let me know if I misheard. And I'm going to give us a few more minutes because I have to get up and take Munchkin to school in the morning.
I thought I have.
Sir, it's I think, a fairly simple question. I'm asking you if you are willing to conduct yourself appropriately.
Okay.
I'll shorten it to that. Are you willing to conduct yourself appropriately, sir?
No.
I have, to the best of my ability.
There you go.
Sir, please answer my question directly. Are you willing to conduct yourself appropriately?
I'm central.
I have conducted myself appropriately.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of 2 witnesses, to conduct yourself appropriately.
Hell no.
I have.
That's not my question. That's not the answer I'm looking for. I'm not asking if you have. I'm asking if you're willing going forward to conduct yourself appropriately during the questioning of these two witnesses. Yes or no?
Hell.
I'm gonna end up getting put back over here eventually.
Because
if
you're a
I come
douche.
over there.
Mr. Brooks, I'm further advising you, I'm looking for a direct answer of yes or no, and that your failure to give me a yes or no answer will be considered by this court to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these two witnesses?
To be 100% honest, I cannot answer that.
All right, then based on that answer, which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward. And based on that, he'll remain where he is. You will remain unmuted. And so if you have an objection, you can lodge that objection within accordance or according to the rules of evidence, sir. All right, with that, let's have the jurors brought back in and we'll start with the taking of testimony.
One quick second to put this up, then you're on.
Go ahead.
Thank you. I don't think it'll take long if you want to call form.
Let's
Non-responsive.
What?
You did not answer yes or no.
Yeah.
All right, do we need to
So
back
that's
out?
Yeah.
Do I need, I wanted to see if the camera angle, so have them wait for a sec.
I
please.
could not have been this judge. I couldn't.
Not going to answer any other questions at this point. The state's setting up a map for use with a witness. I want to make sure that it's something that is viewable on the witness camera that is being transmitted into the courtroom where you are seated. So let me back up.
The whole thing.
Let me back up, zoom out a bit. Attorney Opry, you want to look at the screen above and tell me if you think that accurately depicts what you're going to go over on that map? Do I need to back out a little bit?
Just a little, yeah, because the top of my hand's not showing here. Just a little.
Hold on. I'll go up.
No,
Do you think
don't
with
say
where that
nothing.
chair is, the witness will
I would ask the witnesses to perhaps stand where I am so that everybody can see.
Oh, that would be a good idea. No, you're not muted yet. Mr. Brooks, if you're asking me to make a judicial determination, I've already rendered a decision about where you're going to be. All right, I'm going to mute you, sir. Now we're moving
Oh
on
my
to that
gosh,
part
I would
of the
lose my mind.
procedure since you are you're not following the protocol that I've set in place, that you are back to one of these sovereign tactics about, have I made a judicial determination? The record speaks for itself, sir. I'm not going to make a further record on that, nor will I answer the question about, am I making a judicial determination? I've made a decision, and that decision is you will remain in the other
Hey, Wonder
courtroom.
Joy.
Once the jury is brought back in, I will unmute so that you can lodge objections. But if you interrupt without making an objection and just start talking about a judicial determination, then I'm going to mute you once again. And the procedure for objecting will require that you raise your sign, write it out, and provide it to the bailiff, who will provide it to the court so that I can rule on it. If that slows things down, then so be it. But that's the procedure that I'm going to follow. All right, the jurors can be brought in then.
I certainly did.
As a reminder,
and I'm looking
I'm
forward
not
to
requiring an all rise even for the jurors.
I'm looking so forward to Suitcase Sarah. And like I said, she's America's Karen. She went full Karen today. I don't know how you're so entitled and you are in jail and been there for what, over a year. She's so entitled.
Mike,
She is such a
you
Karen.
have the notebooks. Oh, excellent. Thank you. You can start passing them out.
And still got the Karen haircut. Hey, just me. I am ready. I am ready for Dippity Doo. She got on my nerves so bad today too.
Ladies
Like
and
her
gentlemen, you may
voice
have a
is
seat.
annoying.
And the writing materials will be passed out. Our intent is to call.
Her voice is almost as annoying as Leticia Stout's voice, but Leticia definitely has the edge, but not by much. She's so freaking annoying.
I'll consult with the parties before I let you know what time you should report tomorrow. And keep in mind my time I say we start for court.
Yeah.
Thank you, Judge. State Call Sergeant Dave Warner.
Okay, so we're gonna stop here, and then when we come back, I'll start back with the Sergeant Dave Warner. So we'll come back and we'll start there on day, what is this? This is still day one. We're gonna start back with that and then just proceed on day after day till we finish the trial again. And I am going to cover Suitcase Sarah. I still have another video about Dakota Collins case. And then I'm going to start with the Tiffany Henyard nonsense and Dalton. So anyway, I just want to thank everybody who came through. Y'all smashing that like button. For those of you who shared the stream, thank everyone. For those of you who donated or gave me a kind word, please, if you have any questions or suggestions or comments, of course, put in my comment section, and I, for the most part, respond back to you if I don't at least put a little heart that I acknowledged your comment. All right, guys, thank you so much. I really appreciate you. Mwah, mwah, mwah. Me in my print shirt. Just show that before I leave. She had my print shirt. Been gone 17 days, 17 long nights. Anyway, y'all have a good night. And just like B. Blanco said, drums, please.
Drums, please.
Ladies and gentlemen, we have had a great time tonight. We have truly enjoyed ourselves, and we would like to thank you for being a part of the show and coming to visit this platform. Live on YouTube, Auntie Miracle B. Make sure you come back, because it's always live each and every time. Auntie